Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Hello everyone, this is Anthony Preto. I am going to go through the alphabet soup of public benefits with you guys today on the Third Thursday webinar. So I think you can all see my screen, which is a PowerPoint. You can also email us later this week if you would like to get a copy of that. And I believe the webinar will actually be online for you guys to download and view at your convenience. So we're going to talk a little bit about the roadmap on what happens when something settles. A lot of it is really involved with the starting point of whether or not a client is disabled. And then that disability leads us to two main questions. Are they Social Security disability or are they SSI? One would be a needs-based benefit and one would be one that they've actually paid for, and that would allow them to get SSD and Medicare. We're also going to talk about how settlement trusts and the Affordable Care Act have helped in this space. We'll talk about some different trust solutions too that all the injury victims have when they're recovering money. So the initial question is, why do you need to get involved and why is this important for your client? The biggest thing is when someone is actually and truly disabled and they meet the disability qualification set by Social Security or another determining factor, they sometimes are allowed to qualify for asset-sensitive public benefits and also those public benefits that they've actually paid for through their payroll. So in the planning process, we'll determine what they're eligible for, what they may be eligible for, and what precautions they may need to take in terms of their legal settlement. Does every single person that is disabled require special planning? The absolute answer to that is no. We are not involved in every case that has someone that is disabled. It's only those who are severely disabled and they meet the disability definition that's set by public benefit programs. Even if they're disabled and receiving public benefits, only certain public benefits require planning. The majority of those are the ones that are asset sensitive, or if they are asset sensitive and dual eligible for Medicare, that would also require some additional planning and steps to make sure that they maintain that eligibility. Here's a quick roadmap, just the types of public benefits that are out there. In most states, Medicaid is run at the state level, but Social Security is run at the federal level. So needs-based public benefit planning on that side is done with both federal and state level qualification numbers. You can have SSI, which is Social Security income based on disability. You can also have Medicaid, which is the state-run health insurance that allows those who do not have the assets or the income to pay for health insurance to qualify and receive certain benefits. You also have entitlement programs, which are those benefits that you've actually paid for through your payroll. So if someone has worked enough quarters into the system and becomes disabled, they would actually qualify for a higher benefit, which would be SSDI, Social Security Disability Income. And 24 months from that date, they would receive their Medicare card and be eligible for Medicare benefits. In some cases, people are eligible for both. They receive a portion of an SSI, SSD check, and they have Medicaid and Medicare health insurance. The other benefit programs that you'll see out there with your clients are Section 8, food stamps, SNAP. There's a variety of other benefits that are available to clients in different areas. And then you'll also see the different benefits that are available to veterans through the VA and other military programs. The basics for Social Security income are in the ways you can get them. It's essentially a cash assistance program that provides a monthly check to beneficiaries. It's cash assistance for those who are 65 or older, blind, or disabled. So if you are single and you qualify, you would receive $733 a month. If you're married and both qualify, you receive $1,100 a month. There's no quarter requirements, meaning you don't have to have worked to receive this benefit, but it also has an asset limit cap, meaning that as an individual, you can have no more than $2,000 in assets. As a family, you can have no more than $3,000 as an asset to maintain that Social Security payment. In most states, if you are receiving SSI, you automatically qualify for Medicaid. And Medicaid is basic health care coverage for those who do not have the ability to pay for it on their own. And Medicaid is the one public benefit that actually provides attendant and nursing care assistance. What do you do if your client is on Medicaid and SSI and disabled? The answer is just consider an SST. And what we do during this planning process is sit down with a client and walk them through what a special needs trust is. And with an elder law attorney in their area, we will talk to them about whether or not using a special needs trust, whether it's pooled or standalone, would be an acceptable program for them to maintain their Medicaid and SSI benefits. If the assets are in the name of a person when they're disabled, and getting SSI and Medicaid, and you make a payment to them, directly to them, that would count as a countable asset and would impact their ability to maintain those benefits. Typically, when someone settles a case, the $733 is not what's most important to them to maintain, but the loss of the Medicaid coverage is. So in catastrophic cases where there is attendant care or other sort of nursing care needs, Medicaid is the only program that actually can provide that benefit. So as opposed to being a cash payer when they settle a case and losing Medicaid, a lot of times the client during this initial planning process will make a decision that they would like to try to maintain Medicaid. And using the special needs trust typically will allow them to take the settlement into the trust and maintain SSI and those Medicaid benefits. So when you look at special needs trust, it's important to look at the types of special needs trust and the advantages and disadvantages of each one. So the first type of special needs trust is for those who are under 65, and that's a standalone special needs trust. And it's typically called a D4A trust. And what that means, it's a grantor trust that the injured person who receives the settlement sets up on their own and puts their own money in. So it's an A trust, meaning, or first party, meaning they're putting their own money into the trust. It can have a variety of investments inside that trust. There's no real restrictions on that sort of investment portfolio other than the rules that the trustee would have in terms of being a fiduciary. The second type is a pooled trust, and typically that is for any age, but it does allow people that are over the age of 65 to join. And the main difference between that is you join an existing trust as opposed to having a standalone trust. And the investments inside the trust are typically set between a couple of different portfolio options. So the client would not be able to go in and create their own investment portfolio in that scenario. There are some that do allow that, but in a typical setting, a pooled trust is going to invest and pool the assets into a big pool when they do the investments. And the third one is a third party, which means as opposed to the injured victim putting their own money in there, it would be someone putting money into a trust for somebody else's benefit. And that's the term third party versus first party. So that would be a case if I had a disabled child, I could set up a third party trust with my own funds for my child and put those proceeds in there. It's an important thing to look at when you set up a first party, because typically you want to notify other people that may give that disabled person funds in the future, whether it's a parent, through life insurance benefits or any other benefits. You would want to name a third-party trust as a beneficiary of those, because those types of benefits, when they're received, would eliminate or prevent the person from staying on SSI. Both trusts are not in place. The advantages of special needs trusts are they do allow you to retain SSI and Medicaid benefits. You typically have a professional or corporate trustee in place that oversees the funds, distributions, and makes sure that the beneficiaries are following the PALMS regulations to maintain those Social Security income benefits and the Medicaid benefits. A lot of times a trust will avoid a guardianship, so it would be a this or that scenario. We've seen attorneys ask the judge to, as opposed to a guardianship, let's set up a special needs trust. That avoids the annual accounting back to the court. And the trust can pay for almost anything except for food and shelter, which is what the SSI check is designed to pay for. The disadvantages are it's not an unrestricted, checking account. Beneficiaries cannot call in and get money for anything they want. Cash is typically never dispersed in any scenario back to a beneficiary. It is a sole benefit trust, meaning all of the benefits paid by the trustee need to be for the sole benefit of the injured person or disabled person. And at death, Medicaid has a lien on the trust. So from the date the trust starts to the date of death, Medicaid has a running tab for the benefits that they've paid for and has a right to recover those costs. The only time that is not applicable is when it's a third-party trust. So when other people put their money in place in a trust for an injured or disabled person, those funds are not subject to the same Medicaid repayment. It does add an extra layer of complexity to a settlement, and the trust is irrevocable, meaning once we set it up and the funds are placed in there, it is irrevocable. It's also important when you look at the planning side just to kind of be aware of what assets sort of pass from parents to children and children to parents. So there is some deeming. Sometimes a child's recovery in a settlement will eliminate the parents, and sometimes the parent's recovery will eliminate a child from their SSI and Medicaid benefits. And there's also certain exempt assets based on the state that beneficiaries are allowed to use that would not count in terms of the $2,000 limit. So typically a house and car do not count against that limit. Pooled special needs trusts versus a standalone special needs trusts are a great solution for any size settlement. What those do versus a standalone is it allows the trustee to create a nonprofit entity that manages the actual assets and acts as a trustee. Typically has a low annual fee and no minimum trust deposit. So those deposits into that trust range from $10,000 to $10 million, and the trust can act in a variety of ways that meet that underlying beneficiary's needs. The 4 requirements to create a pooled trust are to have a nonprofit that can act as a trustee. The trust needs to maintain separate sub-accounts for each beneficiary, but the overall investment account can be pooled together. Each sub-account must only be established solely for the disabled person that meets that Social Security disability benefit. So even though they join an existing trust, the sub-accounts are treated directly correlated to that injured victim or disabled person. Any funds that remain at death may either be retained by the nonprofit for charitable purposes or used to reimburse the applicable state Medicaid programs. And then any remaining funds could be distributed back to the beneficiary based on how that pooled trust is set up. Pooled trusts are a little bit different from standalone trusts, and a couple of the reasons are, one, the pooled trust can be actually created by the injury victim, and there is no age restriction. So this is the only trust that someone that is over 65 can actually join. And as opposed to doing a standalone trust document, this is where the actual beneficiary just joins through a joinder agreement an existing trust. A couple of the frequently asked questions that we get would be who can join the pooled trust, and it's the same as a standalone trust, except for people that are over age 65 can join the pooled. It's any disabled person that needs to preserve public benefits such as Medicaid or SSI. The beneficiary must meet the Social Security disability definition of disability. And essentially, that's their inability to work in any environment based on their current situation. How does someone join a pooled trust, and do they need an attorney? To join the pooled trust, you are going to go through a legal document called a joinder agreement. It must be signed by the parent, grandparent, guardian, or ordered by the court. If you are unable to do it on your own, you have got to provide identification. In some cases, a court order might be necessary to establish. So for minors, or incompetence. Typically, a court order is what is needed to establish that. It's suggested by most trustees, but it is not required that legal counsel be consulted or used to actually join the pooled special needs trust. What type of assets can be used to fund a pooled special needs trust? The type of assets are almost anything that is in the form of cash or investment. So cash and other liquid assets in the form of stocks or bonds, money markets, treasury bills, insurance policy proceeds, annuities, settlement, or any other types of settlement monies may be used to establish that trust. Is there a minimum? There's no minimum to opening the account. And funds can be added to the account later, meaning sometimes structured settlements are used as part of the planning tool where an amount of money is seeded and placed into the trust, and then monthly or annual payments are sent in. Also times when a case settles in phases, money is put in initially, and then as the remainder of a case settles, other funds and net proceeds to the disabled party are placed into the trust. Here's the main question we get from beneficiaries is, how do I actually request money? Typically, requests are done through a distribution form where the client fills out exactly what they need, signs off, talks to one of the beneficiary coordinators at the trustee, and then payments are either issued directly to a vendor or sent to the client, addressed to the vendor, or done over the phone. So we can make those distribution requests in a variety of ways. Whatever is typically easier for the vendor and the beneficiary is the way that those distributions are handled. How is the special needs trust taxed? This is for both special needs trusts that are standalone and third party. All of those are grantor trusts. The interest that is created by the underlying investments in the trust are passed through to the beneficiary through a grantor tax letter. Very similar to like a 1099 that people receive. It will outline for the tax preparer what's taxable and what's not. How can people use money? So you can see this, it's very small in this scenario, but it kind of gives you an idea that the main ways people can use money for the trust are for anything that is not food and shelter and not cash. So in order to use funds, typically the trustee will ask themselves, two questions. One, is this in the best interest of our trust beneficiary? Two, do we have the money to pay for it? And three, is it the sole benefit of the trust beneficiary? One of the things the trustee cannot do is ever send cash, but typically health and medical, nursing, anything to do with the client's underlying health maintenance support are allowable, but cash, payments of rent, and things in utilities and food are things that would ultimately impact the SSI check for that underlying beneficiary. ABLE accounts are new, so these have popped up in the last 5 years, and they really are coming into effect over the last 12 to 18 months. And what these allow is for a disabled person that is disabled prior to the age of 26 to contribute funds into a state plan. So their special needs trust can actually make a distribution right into the ABLE account, and the ABLE account is not a countable asset, and it can be used to help pay for food and shelter. So if you've got younger clients who have been disabled prior to the age of 26 and maintaining that SSDI check is important to them, but the 733 is not enough for them to actually pay for their living and food, this is one way to help that. So essentially you can take money from the pooled trust, transfer it to their ABLE account directly in the phases that are allowed, so $14,000 a year. And then that client can use those funds for some of the things the pooled trust is actually not able to do. You can use a structured settlement or a trust to fund that ABLE account, and it does have Medicaid payback just like the special needs trust, but it allows them to use that check or that money in the account to help offset food and shelter costs that the SSI check cannot fully pay for. So SSD and Medicare are a little bit different. They are not income or asset sensitive. They are based on you actually paying for those. So in order to qualify, you have to have worked enough quarters and have been in the system long enough to qualify for those through your paycheck deductions. And once you get it, it's funded through your FICA tax. And once you are eligible, if you become disabled, you do not qualify, or you typically would not qualify for SSI, you qualify for SSD, which is a much more robust plan and based on your actual earnings that you had qualified with. So typically that check is higher. It can be similar to a Social Security retirement check, and that also is an automatic qualifier, just like SSI is typically an automatic qualifier for Medicaid. SSD is an automatic qualifier for Medicare. It does take 24 months plus the 6-month waiting period to qualify for Medicare. So Medicare benefits actually start 30 months from the date of disability. And Medicare is much more like a typical healthcare program than Medicaid. So Medicare has got the different parts. Part A is hospital insurance. Typically there is no cost to that. And then you've got medical insurance, which is what you and I typically pay for through our payroll or through individual policies with Blue Cross, United. So it's the same sort of coverage there. It's an 80-20 payment, meaning Medicare pays for 80% of the benefits and you would be responsible for 20%. And then Part C allows you to opt out, or not opt out, but actually increase that benefit through Advantage plans, which are much more similar to the type of programs that you have at work. Typically, there's a third party that runs those, and it may, you can use Medicare Advantage or Medicare Supplement. All of those are similar in that they are a little bit more advanced than the Part B program. You can also add Part D, which is a prescription drug benefit. So B, C, and D actually have some cost to the underlying beneficiary. Part A is what is paid for directly and has the cost. But it's important to remember that the only time nursing is covered is at the time of like an accident. So if you have Part A and you are injured and you go to the hospital and you require skilled nursing in the hospital and then you leave the hospital and go to a skilled nursing facility, there's a limited amount of coverage for that, and then there would be no custodial or long-term care benefits provided by Medicare. And that's where Medicaid is really different from Medicare. It would provide the custodial and long-term care programs to disabled people. The Medicare Secondary Payer Act is what you guys hear about a lot in legal settlements. So what it says is that payments made by Medicare in the past for your clients and what they can be reasonably expected to make in the future are subject to this act. And it's workers' compensation, liability, and no-fault coverage. And the two ways Medicare looks at it and what your obligations are conditional payments, which mean at the time of settlement, anything you've paid for up until that date, or Medicare's paid for up until that date for your claimant or your plaintiff, you're responsible to pay Medicare back for that. And the conditional payment is essentially the Medicare lien. Medicare set-asides look at the other side. So from the date of the settlement, what is Medicare reasonably likely to pay for your beneficiary in the future? And that requires a professional to do an analysis of what Medicare benefits are and what your client needs and match those up and create a plan that says this is what this client is going to cost Medicare in the future. And that's the money that they would need to set aside for Medicare. So futures, Medicare beneficiaries, Medicare set-aside allocations, all of those things are a hot button in the industry. There has been no real guidance from CMS on what to do in those cases. So a lot of that is almost like a special needs trust. We sit down with a client, we notify them and put them on notice of what is going on in the space, what their real risks are, and allow them to make a decision on how they want to handle that future part of Medicare's interest in their settlement. You only need to worry about this if there's a real reasonable expectation, meaning your client is disabled and you know they're going to get on disability, or they're already a Medicare beneficiary, meaning they've already been shown to be disabled. And what the requirement is that you take the future interest. There is no requirement to do an MSA at all, but there is a requirement to look at what impacts the settlement has if your client's going to be on disability and what that cost is going to be to Medicare, and allocate funds in some fashion to them. A lot of times in larger cases and catastrophic cases where you know your client is disabled, they're going to get SSD eventually and they're going to get Medicare, we can do a Medicare set-aside analysis on the front end, and it really sets a floor for what we know someone has got to pay Medicare in the future based on those injuries. So You do the analysis and maybe it comes back at $300,000 is what the cost to Medicare is going to be in the future. It really sets up the negotiation from that as the floor, meaning the liability carrier is going to at least have to pay $300,000 so your client can set aside those funds to take care of Medicare's future interest. So the Section 111, the MMSEA, which is really the SHIP extension, and what that says is if a defendant insurance company is going to make a payment to a Medicare beneficiary through a liability, no fault, or workers' compensation case, they need to report it. So it affirmatively identifies Medicare beneficiaries. It notifies the defendant will notify beneficiary or notify Medicare that they are actively trying to resolve a case with a Medicare beneficiary. And at the end of the case, when it resolves, it actually identifies the settlement, puts the Medicare beneficiaries numbers in there, and actually identifies the ICD-10 codes. So we need to update the slide, but it's the ICD-10 codes. And what that means is your client, when they settle a case, if they're on Medicare, you should know that whether you're on the defense or the plaintiff side, that underlying beneficiary is going to have ICD-10 codes, which are the billing codes, put into the Medicare portal, and Medicare is going to know they settled the case for how much and for what injuries based on that reporting requirement. If Medicare denies injury-related care, what's the actual process? And this is a real risk for people settling cases that do not account for Medicare at all moving forward. They would go to the hospital and injury-related care would just be denied. So if someone goes to the hospital goes through the process of billing Medicare or seeking billing from Medicare and finds out that there's a legal settlement and they want to deny that coverage, the underlying beneficiary is going to take about 400 to 450 days to be able to get back to that treatment. So there's an appeal and dispute, a reconsideration, the hearing, the appeals in the federal district court. All of them have different times when they will actually go through that process with the beneficiary. So the easiest way to avoid all of this is to look at Medicare's future interest, allocate some funds if you can to help with that, and then give yourself a toolbox to go back to Medicare to say, look, this is my Medicare conditional payment was resolved. My Medicare future payments have been set aside in this fashion with the accounting that justifies what you've done with those funds. How do you define a Medicare set-aside? Settlement money set aside for injury-related medical expenses normally covered by Medicare. So essentially, you're carving out medical funds, the future medical treatment from the settlement money and putting it into a separate account. How is that calculation done? An expert takes the life expectancy of a client, figures out the cost that they're going to cover, that it's going to cost Medicare based on the ICD codes that are related, and the prescriptions that are normally covered by Medicare, and they create an allocation. A couple of things that Medicare does allow you to do when you're doing a Medicare set-aside is what's called a rated age. And this is essentially the opposite of what happens on a life insurance plan. When someone has stackable negative health impairments, it would create a situation that would decrease their life expectancy. So Medicare does allow you to present them with rated ages. So for a 40-year-old, as opposed to life expectancy being another 40 years, you can maybe, if justifiable, you can rate that age, and maybe it will come back at 50, and then the Medicare set-aside is based on 30 years, and that would create a 25% decrease in the total allocation to the MSA, which makes a big difference when you're carving out money from the legal settlements. What's the current state of affairs right now? The legal lay of the land, it has a couple of different things. One, the Stalcott memo, which is a memo from an actual CMS employee, kind of laid out the general obligations and what they're trying to do with the Medicare Trust when medicals for the future are funded. So the defense's obligation is very identifiable. It's detailed. They have to report and notify Medicare. So they know exactly what they have to do. That's not the same for plaintiffs. So the CMS headquarter memo in 2011, and it creates one exception where a Medicare set-aside is not necessary, and that's when the treating physician certifies that there's no future care. So Medicare does not want you to allocate money or carve out money for them if there's no future Medicare covered related expenses in that settlement. So that's one way to eliminate the need for any sort of carve out. In 2012 and 2014, CMS made some attempts at regulations. Those were all withdrawn in 2014. And there's some cases that have set some expectations. So there's the Marine case, the Benoit case, the Sterrett and a Renke case that actually set out some different requirements and different benefits that allow the plaintiffs to know a little bit more of the guidelines that the courts at least are seeing in that future space. So now we had AAJ, the trial magazine, recognize that MSP compliance with futures is on the agenda for CMS. So they put their article out in May of 2016. In February 2017, a CMS announcement came out that said October 1, 2017, Medicare and their contractors will reject medical claims when there was a liability settlement. And all of those should be paid from an LMSA. So that's where the liability Medicare set-aside was named. Liability and no-fault MSP claims that do not have an MSA will continue to be processed under MSP claims processing instructions. So that seems like some good news. But it's still a very gray area. So what do we tell you or want you to identify on the plaintiff side and even on the defense side? These are the things that need to be discussed during the settlement process. If your client's turning age 65 within 12 to 24 months, that's an automatic qualifier for Medicare. So regardless of disability, that's one of the things that would trigger Medicare a little bit quicker. The same thing, if they are severely disabled and you know they're going to be eligible for SSD, then they're typically eligible for the Medicare within that 24-month process. If they have end-stage renal disease, which is kidney replacement, Lou Gehrig, ALS, or if they became disabled prior to age 22 with a deceased parent or disabled parent, those are all people that will be on Medicare. So the litmus test for you is your plaintiff going to be eligible for Medicare now? Are they on SSD now? Are they going to be eligible for Medicare in the future? And if the answer to that is yes, then you move to the next question. Are part of the settlement proceeds going to fund future health care related to this accident? If the answer to that is yes, you move on to the next one. Did you get enough money to actually fund those medicals? And are those medicals covered by Medicare? If you answer yes to all three, then you need to do an MSA. If you answer no to any of them, then what you want to get is some sort of document that says the MSA is not required, and keep that in the file for you and the client. So what we typically do at Synergy, and what I think is becoming more of the norm, is consult with the insurance company when the case is settling, figure out the ICD codes that are going to be actually inputted into the Medicare portal, and then sit down with the client, educate them on, look, these are the ICD codes that are at risk when you settle your case moving forward. Figure out whether or not that's a risk that the client wants to assume, or if the client wants to carve out part of the settlement to cover that risk, they can do so and select the appropriate solution. It does not have to be an MSA. They can do a medical trust. They can do all kinds of different ways to carve out those funds and put the money away in a separate account that has separate accounting. So we call it the CAD process. Consult experts, advise the client on MSP, and then document your file. That's about all you can do in order to eliminate the risk on your risk as a trial lawyer. When you set up an MSA, so let's say we've gotten past that point, the client has decided to set up a Medicare set-aside allocation. We do that through our pooled trust. It's a very low-cost solution, and the pooled trust will allow the client to have their own sub-accounting, so we keep the accounting for them. And that can be a way that eliminates any risk of an MSA administrator or allocator going out of business. The MSA Trust obviously lives with or without Synergy, and allows your client to have separate sub-accounting, and the funds are essentially in their own agreement. When money goes into the trust, it's the same as it is with the special needs trust. It's established through the same rules. The clients put the funds in, and then we make payments directly to the medical providers after doing a medical bill audit. So we'll audit the bill, make sure it is something that's covered by their MSA, and make sure it's something that's actually covered by Medicare, and then we'll make payments directly to the underlying vendors and make sure that the actual billing schedule is appropriate. This is something that has popped up more and more, and probably will change in the future, but how does the Affordable Care Act affect planning? The main reason the Affordable Care Act affects planning is because in the old, pre-ACA days, it was very hard for an individual that had a bunch of pre-existing conditions to get insurance. So now ACA has sort of eliminated that pre-existing conditions requirement and allows people that have some negative health implications still obtain regular health care like a healthy person would. So when we're doing a settlement trust or doing settlement planning, what you want to look at is does it make sense to forego SSI and Medicaid because now you can apply for a typical health insurance policy? In the solutions are really in the details of that underlying settlements. Sometimes a settlement trust with special needs provisions and Medicare set-aside provisions would allow you to make distributions to buy health insurance coverage and forego Medicaid while you can, if you do not need that attendant or long-term care or custodial care coverage that Medicaid provides, and you just need health care coverage. The special needs trust can utilize the tax credits through the amount of income that it sort of generates inside the trust to lower the cost of the premiums and allow you to have typical healthcare coverage versus that Medicaid restrictive coverage. And in the event that you needed the higher version of Medicaid and the more long-term facility coverage, a trust like that would allow you to sort of transition into that typical special needs trust down the road. We think the settlement pool trusts are cost-effective ways to manage settlement proceeds for minors and incompetents. It allows essentially the same type of flexibility that a special needs trust does. There's a corporate trustee. The foundation acts as the trustee. So there's a professional trustee in place. Distributions are handled through the distribution request process, and it's an alternative to establishing your guardianship. The trust is an irrevocable spendthrift that can be used for health, welfare, and maintenance support for the trust beneficiary. So for minors, we will typically have distributions from either the age of majority on, if that's the way the trust is set up, or if they have special requirements from throughout the age of minority, the trust would be making distribution decisions based on what's allowed in that county, in that jurisdiction, and what's allowed based on the trust document. So that's typically the health, welfare, maintenance support, but it also would allow us to make, if it's in the actual agreement when the trust is set up, we can make direct lump sums, almost like you would see from a structured settlement at certain ages. Typically, a settlement trust like that would allow the trustee to make a decision to move the assets into a special needs trust in the event that the beneficiary needs to qualify in the future for needs-based benefits. So it can be a pooled management trust that actually transfers into the disability trust if that's required for the underlying beneficiary to be eligible for Medicaid or SSI in the future. It also is a way to safeguard structured settlement payments. If you make those irrevocably to the trust, so you set up a settlement management trust with some money and you have structured settlement payments going to the trust and passing through to your client, the trust is an interested party if they are ever preyed upon or a factoring company tries to get them to sell those payments. The actual trustee would be notified and they would have to sign off on those payments being transferred. So it's a good way to create a buffer and allow the client to make a better decision if they are solicited by factoring companies. So here's our chart, which I think is really good and a really useful piece for you guys to keep on your desk. But it sort of outlines what trust you need and what's based on what your client is on. So If your client's on Medicaid, you can see that that kind of encompasses the entire right side. They would need to consider the special needs trust and the special needs MSA. So if they're dual eligible of Medicare and Medicaid, they would want to look at a typical special needs trust as a disabled person, which would protect the Medicaid and SSDI, and allocate funds to the MSA side, which would be a separate sub-account of the trust that did the annual accounting for Medicare. If your client is only on Medicare but does not qualify for SSI or Medicaid, they would simply use the Medicare set-aside pool trust. So they would have their own sub-account, and just like in a workers' compensation case, that this would be professional administration. All the payments would be directly made to the healthcare provider so that your underlying client would not have to worry about that. If they're injured only but not on Medicare and Medicaid and just want a spendthrift protection, that's where the management trust comes into play. And that's where we utilize that for guardianship cases or cases where we can buy healthcare coverage because we're not concerned with the long-term care benefits that Medicaid provides, and we can just buy direct healthcare coverage. That's where that trust is really useful. So our pool trust, Pool Trust Services, we've established the foundation for those with special needs. It's a nonprofit 501c3, and it's dedicated to helping people with special needs and supporting other charitable organizations that protect and promote the civil justice system. We use TrueLink as the administrator and back office of the trust, and that allows us to utilize the TrueLink Visa card at no cost to clients as well. And what that is if a client is going to go make a purchase at a store, we can put those funds on the TrueLink Visa card, and the client can actually go directly to the store and make that purchase on their own and take home what they've purchased right at the point of sale. The fees for all of our trusts, the National Pool Trust and the Special Needs Pool Trust, are the joinder fee, which is the one-time fee at inception of $500. And then it's an annual fee of 1.5 of the assets held inside the trust. And that 1.5 is split between the asset management fee and the trustee fee. So there's the assets inside the trust are professionally managed for 75 basis points, and the trustee fee is 75 basis points. The MSA Pool Trust solution is a little bit different. It's a one-time fee that is based on the actual amount that is allocated. So it's between $750 and $5,000 typically. And then there's no annual fee if the prescriptions inside the pool trust are $25,000 or more. So typically in Medicare set-aside allocations, if you've not done them in the past, the majority of the cost now is that prescription benefit. So as long as that prescription benefit is handled through Optum, Optum will pay the fee for your client so that there's no actual annual fee for the Medicare set-aside professional administration. If the RX is less than $25,000, so if they do not meet that requirement, the annual fee for professional administration through our trust solutions is $300 for the beneficiary. Synergy is a full-service settlement planning company. So if you have questions regarding lien resolution, if you have ERISA questions, FEBA, military, private healthcare, and you're having some real issues on the lien resolution side, we are a great resource. Our entire team has about 50 years of collection in that same space that we've hired. So we've got a group of attorneys and paralegals that are from Rawlings and Optum and the different collection groups on that side now work on our side, saving money for the plaintiffs. We provide the Medicare secondary payer compliance, which we've talked about today. We also do structured settlement planning. So in concert with the trust that we talked about today and the settlement consulting government benefit preservation, we sometimes use structured settlements as one of the investment tools. And then for attorneys who do receive contingent legal fees, they have got some special tax deferral benefits that they can utilize in the future to defer the fees of a case that settles today, as opposed to taking the fee now. You can take the fee over time and hopefully reduce that tax burden in the future. So again, my name is Anthony Prito. I am the president of Synergy, and I really appreciate you spending time with us today. Our website is www.synergysettlements.com. We have got a ton of videos and learning material on that site. And if you have any questions, feel free to call me at 877-242-0022. Thank you very much.